We have often seen inscriptions on houses, "This house is not for sale," and this is generating issues about wills and trusts. Most houses have been sold even without family consent and thereby denying owners or beneficiaries of their property. How can this be nipped in the bud? How can such property be protected? Or how can we find respite in the law books? Litigations abound in this regard, but is there a way to reduce the incidence of Igiogbe? Well, joining me in this auspicious moment to do justice to the topic on "This House is Not for Sale, Wills versus Trust" is a seasoned and legal practitioner, senior advocate of Nigeria, and he is Osaro Egobamie. Quite awesome to have you join us on today's episode of Law and You.
Thank you. I consider it a privilege.
Awesome.
Thank you.
So now let's delve into this aspect of the inscriptions, "This house is not for sale." Can you give us a background of what reason you think could be the cause for this notoriety?
I think the first thing to understand is what is the impact of having that inscription, "This house is not for sale." It has far more consequence than you can even imagine. Because when you say a house is not for sale, and you have to inscript it there that it is not for sale, it's now a caution to anybody who might be interested in purchasing that property. And it's also a caution for those who might want to leverage on that property to access the banks. Automatically, you've created what we refer to as dead capital. That property cannot generate income. And let me explain this. If you have "not for sale," it effectively means you are telling everyone that they shouldn't negotiate with regards to anything that will pass capital for the purchase of that property. And in doing that, you are creating a scenario where that property, which otherwise should generate income, you're saying, "No, I would not create a platform where that property can generate income." Now, in other parts of the world, what you have is this property has been sold and capital has moved to somebody else. And when capital moves like that, it adds to the gross domestic product of that environment. You know, when capital moves, when the purchase price transfers to the vendor, to the seller, what happens effectively is the seller is in a position to go and pay school fees, is in a position to go to the market, is in a position to do many other things. And I'll give you an example. If you look at a house where you are decking that house, so this is an old property usually you have not for sale. Normally if it is purchased, you have investors will come in and build something magnificent. Now you stop all that from happening. But if you think about it clearly, when that property is being built, and most times it's a story building, when it gets to the decking point, you have so many people working at the same time. Now, as they're working, money is being transferred. They're buying food, they're buying drinks. All that adds to the gross domestic product of the system. So every time you have the inscription "not for sale," you are effectively creating dead capital and you are insulating that system. And you are creating a situation where there is no commerce.
So by that you're saying that it's also giving the impression that the house is subject to litigation, or that it devalues the property?
Devalues the property. Now, so I said, let's just look at the impact first. And then let's look at what generates it. Often enough, it might be a dispute relating to inheritance. And in Benin, for example, the first son is entitled to the property where his father lived and passed on.
Otherwise known as Igiogbe.
Igiogbe. So the father would normally have sat in that stool, that property, and the father will have liabilities, right? He's taking care of so many people. Children from different mothers, nephews, nieces, cousins. So when that property is handed over, the son steps into his shoes. And the son is supposed to take the assets and liabilities. But in recent time, it takes the assets without the liabilities. Some of those who had been impacted positively by the father's generosity will normally come and say, this house is not for sale because you are expected to continue to take care of me, but I'm not going to allow that transaction take place unless you take me into account. So usually it is often related to inheritance disputes.
Okay, but again, can we also link it to maybe poor documentation of such houses? Maybe
Yes.
in terms of the documents of purchase or certificate of occupancy not being available or other registrations?
So we put it in different categories. When you don't have documentation in relation to property, you can't sell anyway. Or if you sold and you don't have those documentation, you might have difficulties in the future. The documentation you talk about, the absence of documentation, leads to what I refer to as dead capital. The inscription not for sale is usually by those who have some interest or those who think they have some interest who are stopping the sale from going on.
Exactly.
So they are slightly two different things. One, you don't have documentation. That may not give rise to not for sale. You just have to be a bit more careful, carry out proper due diligence before the property is transferred.
Okay.
The not for sale is a caveat, is a caution that you shouldn't go ahead with this. If you go ahead with it, you might be sorry. And usually you will inscribe a caution at the land registry. This is an informal caution, so government is also losing money.
Oh.
Because when you go and effect a caution, you pay for it. But in this case, you simply just write not for sale, and it has consequences which are far beyond what you can even begin to imagine.
Okay. So what's the better way to go about this, most especially if one is to protect the interest of the beneficiaries, for instance?
All right, so let's go to inheritance disputes. The first problem I think we have, especially in this part of the world, is the philosophy that runs behind Igugbe. Igugbe is given to the first son. The original concept was to empower the first son to be able to take care of all the liabilities that the father had. So he empowers you, gives you that house, you might rent out a bit, some of the rooms, to enable you to derive income to take care of your younger ones, to take care of his younger wives. But what happens today is totally different. When the son takes over the property, he actually tells everybody to move out of the property. So you find the first son who might not be responsible and wants to take rights without liabilities. That's where the problem comes from. So I think we need to go back to the old way of doing things, which is that when you train your children, what you put in them is far more important than what you give them. So they understand this philosophy. But if you want it to be professional, there's a way you can get around this problem, which is creating a trust.
Creating a trust.
Yes. Now, if you wrote a will, you must ensure that that house where you lived and passed on goes to your first son. If you don't write a will, it's even more significant that that property goes to your first son. Now, with a trust, what you effectively are doing is transferring the property to a third party who will hold it for the benefit of whoever you deem fit.
Okay.
Now, some will argue that Igugbe cannot be the subject of a trust. I don't think that is correct.
Exactly my next line of question.
I don't think that is correct.
Okay.
There's a Supreme Court case which seems to suggest you can. But if you look at that case carefully, what had happened was the first son was claiming that the property that was given to him was an Igugbe when his father was still alive. You can't have an Igugbe when your father is not passed on, because the principle of Igugbe is that your father must have lived and passed on from that property where he has a shrine.
Okay.
This is the Ekure.
Okay. So you made mention of the advantage of the trust, for instance, in protecting such interest of the beneficiaries. Now, let's look at the aspect of the will. If there is a will, can that also help to protect the property, even if you don't want to involve the trust? Or so, what is the comparative advantage of the trust?
You know, the will is also subject to customary law as far as the Igugbe is concerned. So when you write your will, you must devise the property to the first son. The only way you can circumvent that problem is to basically create a trust, which means effectively you take legal title away from the settlor, the owner of the property, and you deposit that legal title on a third party. What that means effectively is that you really don't have an Igiogbe to give out when you pass on, because the requirements of an Igiogbe is that you must have lived and you must have passed on from that property on the assumption that you own the property. So if you don't own the property, there can be no Igiogbe. On the lighter notes, I tell you, my father used to say that he practiced for many years. He was involved in many of the litigation cases. Says that when a man dies in Benin and has property, suddenly you have a son somewhere who comes and says, I'm the first son, I own the property. He said, but if he's living in a tenanted property, you won't even find those to bury him, let alone his first son. So if you don't have property, you can't have an Igiogbe. I think that's a simple principle. And I don't think that changes. I know there's been a lot of interpretation of some cases to say you cannot give away your property. That will be undermining fundamental human rights.
Okay.
And even in Benin, in the old times, as I said, the basis upon which the Igiogbe principle is predicated is that you have wealth, you've accumulated wealth, you transit that wealth for a purpose. If your son is refusing to take liabilities, he can't take assets. Now, unfortunately, I think 3 Obas away gave evidence and a few other cases which says no matter how recalcitrant your son may be, you must pass on the property to him as an Igiogbe. So, I tell you another joke. My father named me Osaro. Osaro means there is God.
Oh, of course, yes.
He said all the first sons that they call anything Osaro, Osaogie, Osaodion, he said they always beat up their fathers fighting for their properties. But he didn't know the name was so notorious. And that's why he gave me that name. But the idea is that there are principles by which you can circumvent this unfortunate situation we find ourselves. If a first son is irresponsible, then you have no right sitting in the Igiogbe. Because he's taking that Igiogbe for a purpose, not for his beneficial interest.
Well, it's quite beautiful, just in case you're just watching, as Law and you, and we have the opportunity to be discussing with the senior advocate of Nigeria, Osaro Egobamie, and we are looking at "This house is not for sale," which is a popular inscription written on houses, and has been doing justice to what should be done the right way in that regard. And we are using wills and trusts to bring about comparative advantages of getting this done rightly. But again, we talk about a little bit a deepened knowledge on how to get good documentation and registration of such houses, because some houses may be transferred from one generation to another, and if you trace it, they may not have even documents of registration. Now, can you say, or are you suggesting that having a trust or a will could serve as such documents?
A will or even a trust cannot correct fundamental defects relating to the property. So what should normally happen if you don't have good documents? You need to be talking to your lawyers to create those documents. Because there are many ways you can do it. Once you can trace that title to how you acquired it, usually through inheritance, there are various methods by which you can create documents and then apply for the relevant certificate of occupancy. Usually, if it's through custom, you go through the customary codes, yes, and you would swear to an affidavit, and then you would be given the rights to own it. You will be given the permission to then apply to the state governor for a certificate of occupancy. So, for example, my father, his grandfather had left him a huge parcel of land where there was farming. So at that time, the way in which you demonstrate ownership is the ihime tree. When you plant it, and that shows the boundaries through this ihime tree.
Okay.
So, but going forward, you then need to, once you've established that those trees exist, you then need to go and apply to the relevant authorities who will come and survey the place and then translate that informal inheritance into a formal inheritance by asking the neighbors whether they object to this and they know you to be the owner, and then they'll issue the relevant documents. I think it's very important to have documentation, because in the absence of that, again, you cannot use that property to access the bank. You cannot sell effectively. You can only sell to those people who know you. And that's why in a lot of societies like ours, you have an informal system where if property is not being transferred, if property is not being translated into documents, you cannot access capital. And that leads to a depreciation in the gross domestic product.
Okay, so if we're to look at, well, you delve into economics and draw a nexus between legal matters and economics.
Yeah.
Quite awesome. Now, let's have another scenario. A situation where, we keep seeing issues of Igiogbe, generating problems. And are you saying that the documentation should come first before having a trust, or having a will and a trust, or they should be done side by side?
Okay, so you've asked a question that raises different facets of, that requires different facets of answers. The first thing to recognize is that the Igiogbe principle is basically a concept that transfers property from one generation to the other, but limits who you should transfer it to.
Limits it.
That has nothing to do with the documentation itself. So whether there are documents or there are no documents, that asset must go to your first son. It's the principle of primogeniture.
Yeah.
Right? The absence of documentation relates to how you deal with that property as against third parties. That's when I talk about debt capital. That's a different issue.
Okay.
Now, should you use a will or a trust? If you use a will, you must still devise that property to your first son.
Okay.
If you use a trust, there's a possibility that you may be able to transfer that property to a third party other than your first son. So the difficulty here is this. If you have a first son who is demonstrably irresponsible, and you can tell that this first son will not take care of his siblings, this first son will not be appreciative of the asset, this first son will not do anything that you asked him to do. If you use a will and you try to give that property to a third party, the courts will tell you that you have crafted a will that is not in accordance with the law. The property will still go to the first son. And there are many cases in the court law reports. So that's very clear.
Okay.
What is unclear is, can you use a trust to circumvent this complication?
Exactly.
Right. We think you can.
Oh.
There are one or two cases in the Supreme Court that seem to suggest, because they are misinterpreted, that you cannot use a trust, or you cannot give out the Igiogbe as a gift. And that's a different point, but you cannot use a trust. It is being extended, that case. But I said earlier that that case actually dealt with a situation where the claimant, the plaintiff, was asking that the property be awarded to him by the courts on account of the fact that he owned it as the rightful owner to an Igiogbe when his father was still alive.
Okay.
It's not possible to have an Igiogbe when your father is still alive. If your father is the owner of that property, he continues to remain owner until he passes on. Then the principle of inheritance kicks in. It is only after he dies that that principle kicks in. But in this particular case, which is being used as the case to suggest that you cannot create a trust, the claimant was seeking a declaration that he owns the property as an Igiogbe, notwithstanding that his father was still alive.
Oh. All right. Quite interesting, and I believe that you'll be having questions, and we having the number writing on the screen, which is a WhatsApp number and also doubles as the call line. Do well to ventilate your opinion using that line. You can send a short message, we get it, or you can also call this line as we're speaking right now in this issue. Let's make sure that you do the needful, make sure that you go straight to the point, and as we do this, also give us examples that you would want us to elucidate in the next episode. Well, as we come to a wrap, let's look at the aspect of what can we say, or when can we say a man has property, large enough to go on a trust, to bring in the trust. Because we can say, maybe if somebody has just few items, maybe a TV set, a radio set, a table, chair, that's not actually what we can say should be there, because we know trust could also, having that trust or establishing it could also be expensive. So when can we say that such a man can have that?
So I should have defined the concept of trust. Then you understand that it's not about owning large assets.
Okay.
A trust, I can put it across as a description. And the essence of a trust is the very meaning of what a trust is, which is that I'm trusting you. So it's a description of an expression of a situation. I'm trusting you to hold these assets, and please hold it for the benefit of A, B, and C. Exactly. So the question is, can I trust you to do it for me? When I'm no more, will you keep to those
terms?
Yes, those inscriptions. Now, if you had a will, somebody else will be reading that will in quotes, and everybody will see it because you've deposited the will. But in the case of a trust, and you can have a living trust, you can have a trust which is after you've gone. There's nobody reading any documents. So it's just an expression. So if you have a television, or what I call a depreciating asset, the question is, how long is it going to keep that asset for you, for a third party? So you can have a trust of anything.
Or anything.
Anything. The question is, who should you be entrusting? So when you talk about expense, yes, if you use certain trustees and their professions or their professionals who will keep that property for you in the way you've asked for it to be kept, then you have to pay for that service. But what you pay is nothing significant to what you lose when you use either a will or you don't have one at all.
Okay.
Because with the will, it must be admitted to what we say probate. That means it must be read in court before it takes effect.
Yep.
Now, as I told you earlier, once you're reading that document in court, and you have many people who expected that they should benefit from that asset, and they're not benefiting, the next thing is they probably end up in courts. So you find out that 70% of the cases in this part of the world are related to issues of igwe and asset distribution. So to avoid that, so that your affairs are not in the public, you can also have a trust.
Okay, so where does the lawyer come in terms of a trust?
Well, normally you would draft a trust deed. In other words, that document that expresses how you want that property to be held. So just like you need a lawyer to draft a will, although you can draft one yourself, but it's not advisable to do so.
Okay.
You can also draft your trust deed. And all what it means is, if I said to you, my Kana, I'm giving it to you, hold it on trust for me.
Yeah.
Can I trust you to make sure you do so? That trust document or the trust deed will define the terms upon which you are holding that property.
Oh. Big thanks for taking our time to be part of this episode, and we just believe that you oblige us for us to have another very, very wonderful episode with you in subsequent episodes we're going to be having.
I'm very grateful. Thank you very much.
Yes, I've been speaking with Osaro Egobamie, and this has been Law and You. And don't forget to join us same time next week for a fresh episode. I am Philip Omo Gupon. Goodbye.